Hi, everybody. Let me begin by saying that I'm grateful to have been asked to chair such a distinguished panel of speakers. And I cannot resist, as a dual national of two neutral countries, namely Switzerland and Ireland, I cannot resist echoing what the Attorney General Paul Gallagher said in his keynote address, namely that the right approach to international arbitration should not be a matter of competition among legal systems, because such a competition does not help international commerce. The right thing to do for judges and lawmakers, I submit, is to follow a transnational approach to the interest of international commerce. Right now, the topic for this panel is why international law and politics matter to international arbitration. Speakers will obviously tell you why they matter. This is an ambitious topic, especially to deal with in 50 minutes. International law and politics are bound to impact the arbitral jurisdiction in respect of its status and organization, in respect of its procedure, and in respect of the substantive rules it applies. Our panelists will take you on a tour of what awaits us in the world of dispute settlement by means of arbitration, particularly when states are involved. First, Janet Whittaker will present an overview of the many challenges and opportunities facing international arbitration. It is important to have this broad overview because parties, counsel, and arbitrators need to be aware of and to take into account the full context of regulatory and other state actions, which are bound to affect the way arbitration can still function as a jurisdiction. Janet will be followed by Martina Polasek, who will focus on ICSID and ISDS. This is important because it is the main infrastructure for investment arbitration, and this infrastructure will have to be robust because it is going to be tested by the current international political context. And lastly, Thomas Walsh will focus on specific issues, both jurisdictional and substantive, which are likely to be among the hottest issues to come up in investment arbitration in the current context. Namely, the treatment of information and communication technology companies by states, particularly on grounds of national security, and whether and how investment arbitration can deal with these politicized issues. Now, before we begin, I should remind the attendees that WebEx has a Q&A function that allows attendees to send questions via the chat box. And attendees should write their questions in the box under the heading All Panelists, so that the appropriate panelists can deal with your questions at the appropriate time. By the way, I say questions, but it can also be comments. And furthermore, my friends on the panel will also feel free to address questions and comments to the other panelists. Having said that, we can now begin with our first speaker, Janet Whittaker. Is a senior counsel at Clifford Chance and is based in Washington, D.C. Janet practices in the fields of international arbitration, business and human rights, international trade, and climate change issues. Janet, you have the floor.
Thank you, Pierre-Yves, and thank you also to Arbitration Ireland for inviting me to participate today. It's great to feel a little bit closer to Ireland in these COVID times. So they say that to live in uncertain times or interesting times is to be cursed, not blessed. And I leave it to everyone to decide for themselves how they feel about this, but I think we can all agree that we live in interesting times. And over the past several years, the accepted wisdom about the benefits of global trade and globalization, both of which are highly relevant, as Pierre-Yves said, to arbitration, has been challenged. We've also seen new priorities come to the fore, in particular the need to shift to more sustainable economies and also the need to protect and secure technological leadership and innovation. These and other geopolitical developments have impacted international arbitration, and it's impossible in a few minutes to address them all, but I'll briefly raise 4 topics, and Martina and Tom will pick up some of the most relevant and interesting issues. And one point I wanted to make is I think as we think about these developments, it's easy to become gloomy, but I also think it's important to recognize that not only do they present challenges, but also opportunities, and opportunities for investors, the business community, states, and for the international arbitration system and community more generally. So the first trend to talk about is the heightened tensions around international trade and growing importance of national security considerations. I think one development that the Trump administration can take much of the credit for is that it has made trade and investment lawyers great again. The past few years have been characterized by trade tensions, tit-for-tat trade measures and tariffs, measures taken on grounds of national security, and new and heightened FDI screening, as well as stricter export controls and sanctions. Now, they're certainly not all attributable to the Trump administration, but trade issues have certainly become headline news around the globe during his time in office. Some of these trade tensions and the supply chain disruptions have been exacerbated by COVID-19, which I know the last panel addressed. And the developments have also impacted foreign direct investment. I think levels have dropped of foreign direct investment have dropped year on year since 2017, including obviously in 2020, when the estimates are that they may drop as much as 30 to 40% because of the pandemic. The various measures have impacted global supply chains as businesses adapt to disruption and the higher costs that they entail. And I think a key question for the international arbitration community is whether we'll see an increased number of international arbitration disputes due to supply chain shifts. And separately, will we see fewer investment disputes in the future, given the drop in foreign direct investment flows? I think it's perhaps too early to tell with precision, but it will be interesting to look back to see what the impacts have been. The second trend is national populism or the backlash against globalization. I thought I'd just take 2 examples that are broadly viewed as resulting from populist movements, and that's Brexit and the Trump administration. First, we're clearly moving towards the end of the transition period, and it still remains unclear whether a free trade agreement will be reached. The implications and uncertainties for business of deal, no deal are huge. I'll limit what I say to some of the implications for international arbitration and international law. I think in terms of international arbitration, initially questions were raised about the impact of Brexit on the status of London as an arbitral seat of choice. And the consensus seems to be that Brexit will not impact arbitrations or enforcement of awards, especially as the New York Convention will continue to apply. There's also a possible upside to Brexit for investors, as UK BITs of EU member states may survive and escape the clutches of Achmea. And this may make the UK an attractive jurisdiction through which investors can structure their investments into the European Union. But on the less positive side, commentators have asked whether the UK government's internal markets bill, if it proceeds in its current form and gives ministers the power to override certain parts of the withdrawal agreement, in other words, to break international law, will actually have a negative impact on the global perception of the UK as a rule-abiding nation. And I think it's also relevant for us to ask whether this move by the UK government will have a corrosive effect on compliance with international law more generally, not just in the United Kingdom, but also elsewhere. Moving from Brexit to the Trump administration, I think there's a lot that we could say about the administration's impact on international law. But I wanted to focus just on really one arbitration related development, and that's the shift away from the protection of US investors as being a US government priority, which it has traditionally been. And this is particularly relevant in the context of the dilution of investor-state dispute settlement. The current US Trade Representative, Robert Lighthizer, has issued scathing rebukes of ISDS. So his sort of main claims are that ISDS undermines US sovereignty and also encourages US business to offshore investment and manufacturing with detrimental impacts for US workers. Interestingly, ISDS survived in USMCA, but in a significantly curtailed way. So I think here ISDS has lost one of its champions. There is a question about whether we'll see a change under a Biden administration and a new Congress. Mark Cantor in the next session may just take this up, so I'll be brief. First, I think it's unclear what position a Biden administration will take on ISDS. And I think a lot may depend on what happens when Trade Promotion Authority comes up for renewal in July 2021. So the third trend is the reform of ISDS and the rebalancing of investor-state relationship. Martina will speak about the reform process that's underway, and I believe also the EU's push for a standing investment court. So I'm going to touch very briefly on the new generation of BITs and FTAs that seek to rebalance state substantive rights and obligations. I think, in brief, we see a shift both to redress the perceived investor bias in legacy treaties, and second, also to achieve policy goals through requiring certain actions of investors. I mentioned USMCA. We've seen the curtailed availability of ISDS and the limitation of the scope of protections. Another sort of interesting development really in terms of achieving policy goals. I think if we look at the Dutch model BIT, we see provisions that require contracting parties to promote favorable conditions for responsible investment contributing to sustainable economic development. So we see sort of environmental goals creeping in here. Similarly, the Morocco-Nigeria BIT, actually the definition of investment there includes a condition that the investment contributes to the host state's sustainable development. This ties into the fourth trend, which I'll deal with briefly, but it's the global push for sustainability and climate change action. And it's inevitable that this push will define domestic and global economies and regulation in the coming years. It's already relevant in the arbitration sphere. We see, for example, the EU trying to remove fossil fuels from the list of investments protected by the Energy Charter Treaty. And that's really to stop its member states from being sued for their action in relation to protecting climate or mitigating and adapting to climate change. I just throw out a few questions. I think what we may see, will we see states specifically carve out from investment treaty protections investments that involve unsustainable activities? Second, will we see more treaties impose obligations on investors to meet environmental standards or sustainability goals? Will we see environmental defenses, including defenses based on the need to meet Paris Agreement commitments, figure in investment arbitrations? Will other areas of environmental law become more relevant, especially in ISDS? And clearly, I think this will have significant implications for international arbitrations. So lots of key shifts. I think so far the international arbitration community has adapted and institutions have responded to concerns. And I think one thing that we can be sure of is that if political tensions continue, we may actually see an increasing role for arbitration, especially for parties wishing to avoid national courts and who want to take advantage of arbitration's neutrality and sort of delocalized nature.
Thank you very much, Janet, for this compendious overview, quite tour de force, I would say. Before I give the floor to Martina, I would like to say, for those who do not already know her, that Martina has been with ICSID for nearly 20 years, and she is currently the Deputy Secretary General of ICSID and has served as Secretary of Tribunals in over 50 investment arbitrations. Martina, you have the floor.
Thank you very much, Pierre-Yves, and thank you, Arbitration Ireland. I'm very pleased to be here on behalf of ICSID. Now, I wanted to pick up on one of the points that Janet raised about calls for reform of ISDS and focus on the reform work done by ICSID and at UNCITRAL with regard to the main procedural matters that are important to states. I think it's fair to say that these calls for reform is really based on the experience that states have had in cases. It's still a developing area of law, not only as regards the substance, but also as regards the procedure. And so there is a need to adapt to changing circumstances. Now, the question is, how do you adapt and what type of changes are necessary? Some states are in favor of retaining the current dispute resolution system and to redress specific concerns. Some are in favor of more significant reform, such as replacing investment arbitration with a multilateral investment court and appellate body. This is the EU position, for example. States are also considering a multilateral instrument on ISDS reform, a so-called MIRA, that would allow states to opt for reform options of their choice, sort of cherry picking the solutions that they want in their treaty. Now at ICSID, we took the first step to address this call for reform by updating our procedural rules. This is a project that started in 2016, and it's now nearly completed. We're working on the 5th working paper for consideration by our member states. Now, these draft amendments, they address these issues that states have raised and also other stakeholders. But the project is also a modernization of the rules, incorporating best practices based on our case experience, and making the rules more user-friendly too. Now, there are procedural reform discussions also at UNCITRAL Working Group 3. And these are broader in scope, and I think it's fair to say will take more time depending on the means for reform that states decide on. Both of these processes are state-driven with input from other stakeholders. And some of the topics overlap, in particular with regard to those procedural matters that are the most important to states and where they want to see strengthened regulations. So let me say a few words about the 6 main procedural matters and how these are addressed in the proposed ICSID rules. The first is whether or not there should be increased transparency. Now, this was a matter that was already hotly debated at UNCITRAL a few years ago, which led to the adoption of the UNCITRAL transparency rules and the Mauritius Convention. And there is, I think it's fair to say, still no consensus on the approach. Some states want full transparency, and this is very important to them. Other states are only prepared to accept transparency on a case-by-case basis and prefer confidentiality as a default. Now, ICSID's proposal tries to take a balanced approach. We wanted to increase the level of transparency where it would most affect the creation of a stable and consistent jurisprudence. So the focus is on making all awards and decisions public. The second matter is whether and what to extent third-party funding, TPF, should be regulated. Now, it's a relatively new phenomenon in ISDS, and it's most often the investor that obtains funding. So the state concern is that it will bring frivolous claims, that funders are not liable for costs, that investors without assets would be shielded from liability for an award of costs, or that this could create a conflict of interest for arbitrators if it's not disclosed. On the other hand, there's concern that prohibiting TPF altogether might preclude access to justice for meritorious claims. Now, most states agree that there should be some regulation of TPF. So the ICSID proposal focuses on disclosure. It requires the party receiving funds directly or indirectly from a non-party to disclose the name and address of the funder immediately upon registration. And the focus of this is to avoid any conflict of interest for the arbitrators. The third matter is whether security for cost should be easier to obtain. Now, security for cost has been treated as a provisional measure in past ICSID cases and granted only in exceptional circumstances. And in fact, very few cases have met that standard. Now, the main state concern is that the investor will be unable or unwilling to comply with an eventual award of costs. And so many states want to lower the standard for obtaining security. At the same time, states recognize that a security for cost might potentially stifle a meritorious claim. In particular, claims filed by small and medium-sized enterprises. And so this is the access to justice point. There are clearly two competing objectives. Now, ICSID's proposal separates security for cost from provisional measures and lists circumstances that tribunals must consider when they have a request for security for cost. But it does not address the legal standard to be applied by the tribunal. So that's up to the tribunal. The fourth matter is whether or not, whether and to what extent the conduct of arbitrators should be regulated. There is a perception that there is a problem with independence and impartiality of arbitrators in ISDS. And as a result, states want to regulate arbitrator conduct, preferably in a code addressing matters such as double hatting and repeat appointments. Now, ICSID and UNCITRAL have been working on a draft, which we issued earlier this year, and which proposed a range of solutions for these matters. And we received many comments on that, so we'll be working on that soon. The fifth matter is how to make the process faster and less costly. This is the million-dollar question, and something that everyone agrees on needs to be addressed. But the question is really, how? Now, ICSID has proposed a multi-track approach, which concerns all of the actors in the process, arbitrators, counsel, and even the institution. It recognizes that we all have a role to play in this regard, and we all have to make an effort. We also proposed a new chapter on expedited arbitration, which the parties may opt in to use. The sixth and final matter is to make more ADR options available for ISDS. It's important to states for this reform work to have alternatives to arbitration. And ICSID is proposing a new mediation rules specifically tailored for investment disputes, which the parties can use on a standalone basis or as a complement to arbitration. So to conclude, we hope that the proposed ICSID rules can be adopted within the next year, hopefully, so that they can start to apply to new cases and that they can actually inform the further reform discussions at UNCITRAL and elsewhere. Thank you.
Thank you very much, Martina, for sharing your unique knowledge of ICSID and ISDS developments. Of course, if my I was going to say co-arbitrators, but co-panelists have questions, they can jump in at any time. Then we will now hear from Thomas Walsh. Tom is Special Counsel in Freshfield's US International Arbitration Group. His practice is focused on commercial and investor state arbitration, as well as litigation matters and the management of multi-jurisdictional crises and disputes. He has served as counsel in numerous arbitration, as well as in litigation in US courts, federal courts, and he also acts as an arbitrator. You have the floor.
Pierre-Yves, thank you for the kind introduction. It would be an honor to be your co-arbitrator. And thank you to Arbitration Ireland, a wonderful group I'm always pleased to take part in. This is also the one day of the year that I'm guaranteed to make my grandparents proud as Irish nationals. With that aside, I'm going to pick up on Janet's discussion of national security and investment arbitration. And particularly, I'm going to talk a little bit about the new Cold War that is brewing between the United States and China, and the tech companies that have unfortunately gotten caught in the middle. Now, we'll talk a little bit first about the issue, and then we'll talk about potential solutions. So what is the issue? The issue is that states are turning a cold eye, if you will, to foreign tech companies. They're scrutinizing them heavily on national security grounds. This isn't a new phenomenon. China, for example, over the last decade has blocked Google, Facebook, Twitter, Instagram, several other global tech companies from operating in China. So if this isn't new, why are we talking about it? I think because it's a growing phenomenon. This is an issue that's increasingly touching all tech companies, whether they're incorporated in Ireland, China, the United States, or elsewhere. And there's several motivations for states to scrutinize tech companies as security threats. The traditional motivation has been described as one of kind of squashing internal dissension. This is thought to be the motivation of China in pushing out certain social media companies out of their state. Though we're seeing that still today. Turkey is a recent example. In July 2020, they granted themselves, the government did, broad powers to regulate social media within the state. But there is a second motivation for scrutinizing tech companies as well. And it's really, to put it in a James Bond-esque way, it's espionage. The concern, namely that tech companies will be used, private tech companies will be used by state actors to engage in espionage. The reality is that Chinese companies have, whether fairly or unfairly, been the target of much of this scrutiny. India recently banned over 100 Chinese app companies from operating in India. And of course, the US government has, as it does so well, captured a lot of news airtime with its scrutiny of companies such as Huawei and TikTok. And the concern there is that effectively Huawei and TikTok are a Trojan horse of sorts, where China would be able to use their technology to infiltrate certain aspects of the US society and economy. Certainly this perhaps holds up better with Huawei and its involvement in 5G networks. It seems hard to imagine my children's TikTok videos being a source of national security concern, but nonetheless, that is the alleged concern. Will this change over time? It does not seem it will, at least not in the immediate future. By all accounts, President-elect Biden will take a similar position to President Trump. And there's no reason to think China will not continue to act in response to such measures by the US government. So that sounds like a lot of trouble for tech companies, and certainly has been for some, but what can we do about it? There are several solutions. We will talk about one of them, and it is investment treaty arbitration. Are we suggesting that tech companies get involved in investment treaties and bring claims under them? Potentially, but first and foremost, they should think about investment treaties as a point of leverage, part of their negotiating strategy, if you will, with sovereigns that are taking measures that adversely affect these companies. So before a tech company begins to act under an investment treaty, there are, of course, several issues that it ought to consider. We'll talk a little bit about two of them. And the first one is a rather simple point, which is whether there is a treaty available to tech companies. They really ought to, of course, confirm this before bringing a claim. That is, that perhaps goes without saying, but we should all bear in mind that treaties are not always available between major trading partners or global adversaries for that matter. And the US and China are a great example. There's no US-China BIT. I understand that one was once under negotiation, but never came to fruition. And for that matter, there isn't a Ireland-United States BIT. As a result, there are many tech companies that may not have the treaty protections they would like to have, and they should think critically about that before a dispute arises, because of course, you need to be appropriately structured before the dispute arises if you would like to take advantage of the treaty. Now, the second issue, and this is a slightly thornier one, and one where I'll spend a bit more time, is the extent to which the state measure, which the tech company is concerned about, could be portrayed as a national security issue, whether in good faith or not. And if so, whether or not the tech company would be able to overcome such a defense by a state. Typically, these defenses take two forms. There's necessity, the necessity defense under customary international law, and then essential security. And so particularly essential security clauses under investment treaties. As many of you may know, these clauses exist in many treaties. Almost all US investment treaties contain such a clause. And since the 1990s, many countries' treaties have. They typically say in some form that the treaty protections provided in any bit don't preclude state measures that are, quote, necessary to the maintenance of public order or essential security. I'm quoting the US-Argentina bit. There are, of course, many other variations. These treaty clauses and the necessity defense have been interpreted in several investment treaty arbitrations. There was a series of cases coming out of Argentina in the peso crisis, particularly the CMS, LG&E, Enron, Sempra, and Continental Casualty cases. Those all applied the essential security clause in the US-Argentina bit. More recently, there have been cases involving India. And there are really, I think, three core issues that are raised by these defenses. There are, of course, more, but there are three that I'd like to talk about. The scope of the defense, the threshold for raising the defense, and then whether they're self-judging defenses. So what about the scope of essential security and necessity? There's the traditional argument that these defenses should be kind of limited to situations of armed conflict. The reality is they've been, of course, interpreted much more broadly to include economic security. And as a result, tech companies have to assume that any sort of economic measures will potentially be part of that defense. Some treaties expressly limit themselves more narrowly to armed conflict or non-proliferation, but where the treaty is broadly worded, often they're interpreted to include economic measures. And if the defense is raised, what's the threshold? Typically, it's a high threshold. The ILC commentary states that with regard to the necessity defense, necessity will, quote, only rarely be available to excuse non-performance of an obligation and is subject to strict limitation to safeguard against possible abuse, end quote. And these defenses have been interpreted in a few different ways in investment treaty arbitrations. In some instances, the defenses have only been allowed where the measure at issue could be proven to be the, quote, only way forward. In other words, the state measure was the only option that the state had in order to preserve its essential security. The measure would not be justified if there was an alternative, even if the alternative was more costly or less convenient to the state. There have also been decisions that have taken a slightly lower bar or set a slightly lower bar, and they've used the, quote, reasonable available test. And of course, that suggests that there could be several options available to the state as long as, and they're excused as long as the one the state took was reasonable. Now, there's a great deal of debate about whether this high threshold makes sense. Many say it does. I think in making that evaluation, it's important to bear in mind that these investment arbitrations are not seeking to overturn state measures per se. They're just seeking to determine whether or not the state measure was excused from compensating the investor. And of course, investors can be damaged by these state measures, and it's fair to take into account the damage that's caused to them. They are, of course, not faceless corporations, but there are people behind them, and losses are felt. And so there's a balance to be struck. And of course, there's also the view that if there's a broad exception for national security with a low threshold, it will effectively rob bits of their protections. And so the third issue will be whether the treaty provision is self-judging. And this is one that has not been the subject of many decisions, but is the subject of much controversy. Effectively, who decides when essential security is present? Beginning in approximately the mid-90s, many treaties started to bake in new language in essential security clauses that provided that measures that were, quote, considered by the state to be necessary were excused. And so it was the state that got to decide whether or not the measure taken was actually one that should be excused under the treaty. Now, the question remains, does that mean that the states are not subject to any type of review? And this is a thorny issue. If there's no review, are we creating a loophole? There's also the question of, do states not want their counterparty states to have some level of oversight? Don't they want to ensure that their foreign investors are protected? And if states' elections of national security are subject to at least good faith review or some other level of review, what should the standard be? I think the general assumption is that the standard should be good faith, though there's certainly no set view on that. And then, of course, there's the general question of, is it even acceptable for arbitral tribunals to be reviewing decisions of national security? And there, I think the conversation often goes back to the point that arbitral tribunals are not looking to stop states from taking certain actions. They're just trying to decide whether or not the state's actions are excused and whether or not the investor should receive some level of compensation. So a number of thorny issues, all things that tech companies ought to take into account before pulling the trigger on investment treaty arbitration. And certainly the Cold War that is brewing between China and the United States could potentially lead to some arbitrations that will shed some further light on these issues.
Thank you, Tom, for your informed analysis. I would say that tech companies would be well advised to take heed of your valuable analysis. Now, we still have a few minutes for questions. I haven't seen any in the Q&A section, but I'm sure my co-panelists would like to ask some questions.
Well, maybe I can start on Tom's part, since we ended with that. You mentioned all of these developments and the essential security clauses, and I'd really be interested to hear if you think that given these developments, states will want to strengthen their essential security clauses. I mean, so far as I'm aware, most tribunals have ruled that it's not self-judging. But do you think that might change? Or do you think, given the current pandemic and climate change and all of these really important issues, that states will want to regulate more in that area?
I think you're absolutely right, Martina. I think states will want to draft their treaties to be a little bit more state-friendly. And I think we've already seen that. Essential security clauses have existed in BITs for a long time. And it was in the mid-90s where you really started seeing self-judging clauses being baked into BITs. It was part of the US's 1992 model BIT. And so they've been around for a while. And many, well, I shouldn't say many, but investment treaty tribunals have come to the conclusion that unless the clauses are expressly drafted to provide for self-judging, they won't be self-judging. But then the question becomes, even if they are expressly drafted to be self-judging, is there really no review? And can you draft a clause that would really provide for no review? And would states want to, bearing in mind what effect that could have on their own investors?
I had a question for Martina about the sort of level of state engagement in the amendments, sort of the reform process. And, I'm interested to know whether the level of engagement has been sort of uniform across or widespread across geography. So have we seen sort of engagement from north, south, east, west?
I was, that was one of the big surprises for me to see the level of engagement worldwide. It's really is broad across all geographic regions of the world. We have 154 member states of ICSID, and roughly 80 of them participated. And that's a really tremendous number if you compare with previous amendment projects that we had, where we basically didn't receive any comments. And we've had in-person consultations with many member states present during that those consultations with really robust discussion. So yes, it's been really nice to see that engagement.
I have a question for Janet, if I may. Janet, going back to your, I think it was your fourth topic, the global push for sustainability. I was curious, from your perspective, how might questions of international environmental and human rights laws become relevant in ISDS? Do you see that coming in via counterclaims or other ways?
It's a really interesting question, and I think it really, to some degree, depends on the treaty and also the relevant context for that treaty, including sort of the willingness of states to take action in their domestic systems. I think from the ISDS perspective, we have little guidance from what's happened to date. We've certainly seen the possibility of counterclaims being raised, for example, Urbasa in Argentina, Burlington in Ecuador. We're likely to see, with provisions in the Morocco, such as that in the Morocco-Nigeria treaty, if we see more provisions that actually condition the definition of investment of actually meeting some sustainability goal, we may have some jurisdictional issues that arise. I think also from the point of view of defences, it may be that investors should be aware that tribunals will interpret investor protection standards in light of sort of international and domestic human rights environmental standards. And I think that may even apply in relation to treaties that don't expressly incorporate those standards. And I think one of the really interesting things to think about is that something like 2/3 of UN member states actually recognize the right to a healthy environment in their domestic legal system. So actually under domestic law, there's quite a lot of support there for environmental interests. So we could see it there. And then, of course, we might see it in issues of valuation. We've already seen that possibility arise in the Bear Creek mining and Peru case.
Anyway, just to follow up to that, though it's a little different, I'd be curious if you think the Chevron Ecuador case presents some inspiration for allowing counterclaims in investment arbitration rather than allowing them to go to local courts.
And I think that, and then Martina, you sort of raised this issue about whether, the fact that we see a lot of treaty amendments, and I don't mean to put words in your mouth, I certainly speak, but we see a lot of treaty amendments, but we don't necessarily see a lot of treaties including provision for counterclaims. I certainly think that, the actual substance of the treaty, what it says counts, the possibility of bringing a counterclaim, whether counterclaims fall within the tribunal's jurisdiction. For investors, presumably they would, in certain circumstances, prefer to be dealing with the state in an investment tribunal context rather than in domestic courts. But I think ultimately that decision very much, the possibilities come down to what the actual treaty says, not necessarily something that no one wants a counterclaim. So, and I don't know that one can determine at the outset what the possibilities are, although obviously looking at treaties for the possibility of counterclaims will be relevant to any claimant who's filing a claim. But more broadly, I think that it will become more prevalent for investors to sort of think about the broader context as we see sort of more cases in this area.
I see we have a question from the audience which touches on this, but also on essential security. So I don't know, maybe Tom wants to answer this. Would climate change measures potentially fall within essential security?
That's a question I would love to dodge, but I'll take it. I don't know, but that is an excellent question, and certainly an issue that will probably come up in the future, unfortunately, given the circumstances we're all living in. And given that economic measures can be interpreted to be part of essential security, and climate change certainly has economic impacts, I would see various avenues for bringing in measures to combat climate change as a potential essential security defense. But of course, it would depend on the measure and the necessity for it, bearing in mind the high bar. And given the nature of climate change and it being something that is simply a local issue, but rather a global issue, it could be hard for states to say that the measure they're taking meets the necessary threshold. That is the only measure they could take, for example, that's truly necessary. So I could see it coming as a potential issue, but I could see it being a very hard point to argue under the actual threshold of necessity.
That's a very nuanced answer, Tom. You can still be appointed an arbitrator when this issue arises. I think if I'm right, I think we're running out of time. Or are we?
We still have 2 minutes, I think. Yeah.
2 minutes. Okay.
Yeah.
Well, then I think we probably have to wrap up at this point.
Well, there is another question from the audience, and I'd be happy to answer that in really one word. It says that, do the panel have any sense of how the EU's apparent objective to have an investment court is likely to fare in any future trade talks with the US? And at least my answer to that is no, I don't have any sense, really. It's very hard to say. Janet, you might have something to add.
I would say, a couple of things. I think number one, right now there are no trade talks going on with the EU. That may change. I think it depends on what they look like. We've seen a lot of mini deals and mini trade deals by this administration. It would depend very much what a future trade deal looks like. Would it include an investment chapter? And I think it comes back to the sort of the point that I made before, what would happen under a Biden administration, but also what the US Trade Promotion Authority says about investor-state dispute settlement. Is that, is it something that remains part of one of the US's objectives in trade talks? And the one sort of positive here is that the investment court is not immediately around the corner. So time will tell how the existing investment courts have fared. That may sort of play into sort of consideration of what role, if any, it would play in those talks.
Yeah, I might add that we might have some insight in the next few weeks as President-elect Biden appoints his cabinet, and we'll get a sense for whether the progressive wing of the Democrat Party will have a strong voice in the White House or not. And if they do, there could be more of an interest in more ISDS reform. If they don't, there may be less interest. But it remains to be seen.
I think this time we don't, unfortunately, we have to wrap up. But in doing so, I want to thank our speakers for their very valuable insights as to how international law and politics are going to impact arbitration. They have gone a long way to show that we are in crucial times where paradigm changes are occurring in commerce and therefore also going to drive changes to arbitration. And we are very grateful for that. Before I close, I'm told I must say to the attendees that we are going to have a 5-minute break before the next panel starts. Thank you very much. This closes the session.